Hello, I'm Tom Downs, and I'm here today with Justin Wedgewood, who's an associate at our law firm. And Justin, you've been with us for
about 3 years.
3 years, and it seemed like yesterday, and it seems like forever. No, it seems like yesterday. We wanted to talk today about joint ownership. And joint ownership is a format of ownership where you and I could go to the bank and open a joint bank account. If I die, it's your account. If you die, it's my account. And there's some beauty to it because it's very simple. But we can talk about possible unintended consequences too. And I'll start off with a story of a lady that I worked with years ago who had about $400,000, and she had 200 in one account, and she had 200 in another account. She had two nieces that she wanted to share the assets with, and she put one niece on one account and one niece on the other account. And if she had died, they'd have both gotten $200,000. The plan would have worked wonderfully. But she didn't die right away. She ended up having long-term care. She went into a long-term care facility, and as a consequence, she needed a lot of that money spent to take care of her. And her one niece started writing checks and was writing checks every single month, taking care of her aunt dutifully. And the other niece would not contribute, and she kept coming back to her and saying, hey, we need to have some of this money. When the lady died, there was about $20,000 in the one account. There was over $200,000 in the other account. Those nieces aren't talking to each other, or at least they weren't back when this happened. And the person who had done right by the lady really got the short end of the stick. And with proper planning, that could have been avoided.
Yeah. I see that a lot with clients who come in for a consultation. They think they have a good plan in place because they've solved the probate issue by adding someone on as a joint owner on the account. But often they fail to recognize some of the downsides of doing that, right? If the other joint owner had creditor issues or some sort of judgment against them, that exposes their bank account, but for all practical purposes is their account that they're using as their own. It exposes that to their creditors, to their liabilities.
Correct. I like to tell people you don't want a plan that's too simple, and you don't want a plan that's too complicated. And the beauty of joint ownership is you can do it yourself. It's very easy to do, and it will probably work. And then the question is probably a good result. I'll give you one other little story. I had a man who had about $400,000. He had a house, and he had a will that gave his house to his 4 kids, and he had a joint bank account with $200,000 with his daughter. When he died, the daughter got the $200,000 from the joint bank account and a quarter of the house. So she ended up with $250,000, and her brothers each got $50,000. And she was sort of like Tommy Smothers, Dad liked me best. Right. But also she had done a lot for her father. That may have been what he intended. One of the problems with having things vague is that they're vague, and people can then have damaged relationships. And part of our job is to try and convey what you really want.